In the first video called Introduction to Intellectual Property Rights for Designers, we went through what intellectual property and intellectual property rights mean and how can IPRs be used to protect design. In this video, we are going to discuss how designers and design-driven companies can utilize their intangible property and intellectual property rights in a strategic way to build sustainable and successful businesses. Creating an intellectual property rights strategy is very important for a designer and a design-driven company, but the word IP or IPR strategy can feel overly complicated. So we're going to break down what this means in very practical terms. You have created an IP strategy if you have contemplated and answered the following questions. 1. What intellectual property do you have? 2. Which aspects of the intellectual property can and should be protected? 3. How will you utilize your intellectual property? And 4. What is your plan for managing and enforcing your intellectual property rights? Or, in short, you need to identify, protect, utilize, and manage your intellectual property. My name is Iiris Adenius. I'm a Finnish lawyer and an economist, and for the majority of my career, I have advised designers and design-driven businesses on their rights. As with the previous video, we will focus on EU legislation, and this video is provided for information purposes only and should not be considered as legal advice. Always reach out to a lawyer or IP advisor for specific IP advice in your situation. What intellectual property do you have? Sometimes identifying intangible property can feel difficult. But let's start by looking at some simple examples of what constitutes as a company's intellectual property. Let's say you're opening a cafe, and your options are that you will start everything from the beginning. And so there is a lot you need to do. You need to find and rent out the right location, decide on the name of the cafe, set up web pages and social media accounts, plan the menu, source all ingredients, products, appliances, and furniture for the cafe, find the right suppliers and negotiate contracts with them, decide on a logo for the cafe, test if there's demand for this type of cafe in the area, find the right price points for each menu item, market the cafe, find employees, and make employment contracts with them, and figure out a profitable way to run the business day to day. If you go through all that work, you have created intangible assets for your company. Your other option is to franchise an existing concept for a cafe where someone else has already done all or most of the things listed above. And by franchising a cafe concept, you're actually getting the right to utilize the intangible property that someone else has already created. IP legislation and IPRs are the reason why you cannot simply copy what another cafe has done, but you need their specific permission to do so by franchising or licensing those rights. From an economic perspective, you are reducing the risk of opening a brand new business by utilizing an existing concept that already has a track record of performance and has gained trust among potential customers. And the franchising or licensing fee is a fee you pay for the reduced risk. The same concept applies to any other business, including a design-driven business. The intangible or intellectual assets of a design company could include customer lists and contracts, supplier contracts, databases, brand recognition and goodwill, market research and insights, domain names and social media handles, marketing materials, employee expertise and experience, and even email correspondence. In addition, all the products and services that the company has, including products or service manuals, pictures of the products, a specific pattern that's used in the product, technical solution, a type of packaging, could all be part of the company's intangible assets. Another important aspect to consider is whether there are important intangible assets that could be useful for your business and that you need to acquire through licensing or buying, for example. Lastly, after identifying your company's intangible assets, it's time to assess in which countries you're going to operate, keeping in mind that IP protection must be applied for in advance, in some cases before the design, creation, or innovation has been published. Creating an IP strategy is inseparably linked to your business strategy. So typically this first step of an IP strategy could or maybe at least should be answered with a business strategy. Which aspects of the intangible property can and should be protected? After identifying all the intellectual property that a company has, it's time to figure out which aspects of the intellectual property can and should be protected. Many intangible assets can be protected with intellectual property rights. Brand recognition and goodwill can be protected with trademarks, trade names, domains, and social media handles, but also with other forms of protection, such as good marketing and PR strategy, and contracts, for example. And many products and services rely on trade secrets and company policies as their primary form of protection. When you create an IP strategy, it's important to view intellectual property as a whole and realize that there are many avenues for protecting intangible property, and those avenues are not all intellectual property rights related. However, IPRs give their holder the right to prohibit actions by others, and this is why it is important to find ways to protect intangible assets with intellectual property rights. Because different types of intellectual property rights give their owners the exclusive right to utilize this property. You can categorize IPRs in two main categories: company-related intellectual property rights and product and service-related IPRs. Company-related rights could include trade names, company-specific trademarks such as brand name, logo, slogan, but also domain names and social media accounts. And product and service-related IPRs include rights such as designs, trademarks, patents, utility models, copyrights, trade secrets, etc. The difficult question to answer is what parts of the intellectual property should be protected with IPRs. To make matters even more complicated, one form of intellectual property, let's say a pattern or a shape, could be protected with several different forms of IP protection: an EU design, trademark, or copyright, for example. So let's view the situation from competition point of view. In case you have a physical product, a light fixture, for example, you need to establish why a customer would buy your product over the similar products in the market. So in other words, you need to figure out what creates a competitive edge for your product. The aesthetic appeal could be one of the key factors why customers like to buy this specific product, but there could be other reasons as well, such as functionality, the use of sustainable materials and manufacturing process, and the easy availability of the product in retail or online stores. So how can these features be protected? The best tool for protecting the appearance of a product is utilizing design protection. And as mentioned in the previous video, design protection can be achieved EU-wide with a single application by registering the design with the EU IPO. In case the design is new or novel, meaning that it has not been published before, and it has an individual character. The appearance can also be protected under copyright legislation in case the design is considered original enough. And in rare occasions, the design could even be protected with a 3D trademark in case the design is distinctive enough that customers clearly associate the design with your company. Functionality as a technical function could be protected with a utility model or a patent. Functionality that is related to the shape of the product can sometimes be tricky to protect. As a design, a shape that is dictated by its functionality cannot be protected with a design right. However, many decisions that enhance the functionality of a product are not necessarily dictated by the functionality, and so it is advisable to reach out to a design attorney to assess your specific situation. Making sure that your manufacturing process is sustainable, from material sourcing to manufacturing conditions, as well as ensuring access to good retailer stores, can be achieved with good sales and operational efforts, as well as good contract negotiation and management skills. And this is why contracts are an inseparable part of an IP strategy. One important thing to remember is that the features themselves cannot be protected with IPRs. Other companies can also create aesthetically appealing, functional light fixtures that are available in retail or online stores. But your specific expression of this type of light fixture, along with its marketing materials and brand value, can be protected against copying. Regardless if the design company sells design services or concentrates on physical products, brand protection is key to help customers distinguish the design company's products or services from similar ones on the market. Up to 90% of some companies' value have been estimated to derive from brand value. So, this is an aspect that no company can afford to overlook when deciding what to protect. Reach out to an expert to figure out what aspects of your intangible assets could be protected with intellectual property rights, and check out IP scan services on EU IPO's webpage for more information. After you have identified your intangible assets, decided what can and should be protected, you must also remember to check that no existing rights prevents you from registering your rights. The last step is, of course, to file for IP registration, especially industrial rights such as designs, trademarks, and patents, and decide in which countries to register, aka in which countries to get protection. Overall, figuring out what aspects of intellectual property should be protected is closely linked to understanding the company's competitive edge and business strategy. Deciding how to utilize intellectual property and IPRs. There are three typical options for designers to utilize their intangible assets and intellectual property rights. No option is inherently better than another, but each option requires its own set of contemplations and preparations. Most often, designers decide to either license their design to a customer, or commercialize their own products or services, or sell all rights to a customer. Licensing your design. Very typical way for designers to utilize their design is licensing the design to a third party, who will then in turn manufacture, market, and sell the products that utilize the design, in exchange for a royalty and/or licensing fee. License is an explicit permission given to someone to access or utilize your intellectual property. License is a very versatile contract form and probably the most important contractual tool for designers. Licensing allows designers to remain as owners of their design, but also allows customers to utilize the design. The benefit of this model is that the designer can focus on their core skills and leave business operations to another party. Licensing also allows for the same design to be licensed to multiple customers, making it a great tool for scaling businesses. Another benefit is that licensing can be used as a risk-sharing tool and as a way to form partnerships as well. Licensing is also a widely established form of contract globally, and the variations for licenses are endless. As with all contracts, it is important to make sure that the contract as a whole is balanced and well thought out. Pay attention to upfront payment terms or royalty percentages being based on clear figures and clearly defined exclusivity terms in case the license is exclusive. Additionally, make sure that there are no unnecessary risks left to the designer in the form of a harsh indemnity clause, for example. Again, please turn to a lawyer for advice in your situation. Commercializing your own design products or services. Commercializing your own products or services mean that you will be in charge of overviewing every aspect of your business, from designing, manufacturing, establishing sales channels, marketing, pricing, and finances. When you commercialize your own design products or services, make sure to have enough resources in terms of money, time, contract management, marketing, bookkeeping, and cash flow management. When it comes to intellectual property management, this option requires most knowledge and active involvement with your intellectual property rights, from protection to enforcement. But at the same time, it is good to remember that only about 10% of small and medium-sized enterprises protect their intellectual property. So an SME can gain significant advantage by being active on protecting and safeguarding their IPRs. This option typically requires risk tolerance and sufficient initial investment and resources to start the operations. Of course, you do not need to do everything alone, but finding the right partners is key. Despite the high requirements, many designers find commercializing their own products and services rewarding as it allows designers to decide exactly what kind of business they like to run and reap the full benefits of their own labor. Selling your design. Especially in situations where a customer has hired a designer to design a product or service for the customer from the very beginning. The customer typically insists on buying all intellectual property rights related to the design. Typically, when a designer sells their design and the IP rights related to the design to another party, the designer receives a flat fee compensation for the work done and for the IP transfer. It's good to notice, however, that royalty payments can also be used even if the rights were transferred to another party. As assessing the value of the design is difficult, especially in advance, royalty payments are a great risk-sharing tool, also in case of IP transfers. Once the design is sold, the designer typically has no rights left to the design, so it is important to agree that if and how the designer is mentioned as the designer of the product or service, and to include reference rights for the designer, including the right to use customers' pictures in their portfolio, for example. Another important consideration is to make sure that the designer is not left with unreasonable IP liabilities after the IP transfer is concluded. Plan for managing and enforcing intellectual property rights. The last part about an IP strategy is making a plan for how to manage and enforce your intellectual property rights. Managing your rights means that you must, in many cases, actively monitor IP registers, such as EU IPO's trademark or design registry, and oppose in case someone else is trying to register a right too similar to your right. You must also remember to renew your industrial rights, and in order to uphold trademark protection, genuinely use the trademark. As a right owner, you must also actively monitor marketplaces, websites, and social media for potential infringements. You can do this by using online search tools or hiring professional help. In case a potential infringement is detected, it's good to have a protocol in place to assess the situation. The assessment means making sure you understand what rights you yourself have and that those rights are valid in the region where the possible infringement took place. It makes a difference what type of intellectual property rights you have. Different forms of IP rights vary in terms of requirements to obtain the rights, threshold for getting the rights, and the time of the exclusivity provided, but also in terms of what constitutes as an infringement or breach of the right. For example, design can be protected with both design right and copyright. Copyright legislation does provide protection against copying the work, but also allows for even identical independent works to exist, as long as no copying was done in either case. Whereas design right gives protection against someone bringing to market a design that gives a similar impression of your design, even if the other design was created completely independently. Once you have established that your IPRs have potentially been infringed, it's time to take action. The next steps could include gathering evidence, sending a cease and desist letter, starting takedown procedures for web pages and domain names, requesting customs to detain or suspend goods at the border, negotiating a deal with the potential infringer, or engaging in a mediation process with them, or ultimately taking legal actions against the potential infringer. It's good to refrain from making direct accusations of copying, especially publicly, without very careful consideration. It is extremely important to consult an experienced IP expert or lawyer in potential infringement situations. A few words about artificial intelligence and designing. At this point, we do not know how AI will affect the design industry in the future. But the important thing to remember is that the current IP legislation is based on an assumption of a human creator, meaning that many IP rights can only be achieved in case there is a human creator behind the work. Thus, a design or other creative works cannot be protected in case they were created with AI. Thus, having a human designer behind a design is in of itself a competitive advantage that allows the designer or the owner of the design to obtain IP protection. To summarize, the steps to create an IP strategy include identifying all intangible assets, protecting those assets with intellectual property rights, contracts, and other measures, deciding how to utilize intellectual property, and last, making sure that those rights are being managed and enforced. When it comes to IP management, it's good to be on time with the decisions, as many rights can only be obtained in advance. Using expert advice pays off, and there are many public funding opportunities to cover for some of the costs related to IP protection. For example, the EU IPO has an SME fund that allows small and medium-sized companies in EU to apply for direct financial support and assistance to protect their intellectual property rights.